Today, today we are going to present the what to do for the registration, and also what are you expecting in 2020. Give me 1 second, guys. I'm a little bit new to this screen. Oh, come on.
The total fee that you pay once you click submit. You can't submit the same person more than once. The information that is needed to submit is quite easy, so that's a good thing. You only basically need the employee's name, passport number, date of birth, and whether they are being filed under the master's cap or the regular cap. So it should be relatively quick and easy to submit the registration. Once that period closes on March 20th, then by March 31st, they will complete the lottery and inform all of the employers only which of their individuals were selected. So you should receive a notification either by text message or email. That notification will not tell you exactly who was selected. It will just tell you that there's been an update in the system. Then you have to log back into your account, and then you can see who all was selected. Once you find out who all was selected, you can immediately start filing petitions on April 1st, and you can file all the way up to June 30th. So it does, the filing window that you have. And again, this is the biggest benefit is now you're only filing for the people that were selected instead of preparing petitions for everyone and then having half of them sent back to you.
And then also for the people who are going to file the H-1B application, previously, we used to file without the end client letter, without the vendor letter, without all those things, because we just want to beat the deadline. Now, the lawyers, the employers, and the HR will have enough time to collect the documentation to submit the end client letter, vendor letter, MSAs, SOWs, and all those things. That's another great advantage too. Emily, with regards to the people, what warnings you want to give to the people? Because we have seen in the past 2 years, so many of these employers, the rogue employers filing H-1Bs for the employees that are not working for the company. Previously, it was costly because they were filing with thousands and thousands of dollars. Right now, Emily, there are a lot of employers who are willing to defraud the administration, and they don't care what happens with the employees. Now, it's only $10 for them to defraud, by even though they don't have a job, even though the employee is working somewhere else, there will be a duplicate filing. What do you expect how the USCIS, how the ICE, how the FBI have done previously, and how they are going to do it in future?
Yeah, it's going to be a major difference because now all of a sudden this lottery is done electronically. That means that your company is logging in and entering the information. And they've already come out and told us in the regulation that if a company receives, multiple registrations, but doesn't file that same number of petitions, they could potentially then put on a potential fraud alert. That company is just filing a bunch of registrations and not actually having work available, not intending to file the petitions. So for the individuals, we would definitely recommend to shy away from these duplicate submissions. It's got to be a legitimate company. The company that you're actually working for is the one that should be registering on your behalf. And not only is it possible that the company gets a black mark or the company gets in trouble by having so many registrations but not having the petitions actual filed, the individuals, those are the ones that from 6 years ago, 4 years ago, 3 years ago, filed multiple petitions. We're seeing impacts now, several years later, where they're getting that initial petition revoked due to fraud, that means they're no longer counted in the cap. They have no way to stay in the country. So it is a huge risk to take to try to submit these multiple submissions. You know, don't trust your friend of a friend of a friend who says they know a guy that is going to register for you, because just think about, I think we're all familiar with the University of Farmington students and how they were able to recruit so many students into doing the wrong thing with this school. It's because they knew a friend of a friend or someone referred them. It was never the student going out and purposely doing these things, as they were told about this school from a friend and they assumed that it was legitimate. So same thing here. If you are not familiar with the company, if you've not worked with them before, it's a huge risk to have that company submit a registration.
Even if you know the company, guys, don't go to the companies that are not working and file duplicate. There's a lot of prosecution that I heard last year. We expect the same thing this year. So please be mindful on that, what you're doing before you go. Just because it's easier, just $10, don't do it. I want to go over with the 2019, what happened in 2019 for you guys, so that we can guide you what is going to happen in 2020 with regards to the entire immigration that's concerning to the business immigration. One is that the Fairness and High Skill Immigration Bill has been passed in the House with 365 to 65 votes. That means 365 in favor, 65 against. It was passed in the House, which is the lower house. And when it came to the Senate, it got stuck there. It's still there. So any of you guys, please write letters to your senators to pursue this bill. There is a new rule that came into effect in October 2019, public charge, which increases the burden of paperwork on a lot of people, including the employment-based immigration. Though the employment-based immigration people might not be affected, it increased the paperwork burden. However, that got blocked by the court at this point of time. We also noticed that in EB1 has been backlogged for Indian nationals for 2019. We haven't seen that significant backlog ever. I've been practicing immigration law for more than 25. I've been practicing as a lawyer for more than 25 years, 23 years, and 2 years in addition to that, I've been working in it. I haven't seen an EB1 backlog to such great extent. And it is expected that the EB1 backlog is going to continue for the Indian nationals and also to the Chinese nationals. We have also seen that the I-539, especially the L2s, the H4s, and EADs that used to be approved along with the H-1Bs or the respective L1s, they are not adjudicating because of the fingerprinting requirement. They are taking up to 11 to 12 months to adjudicate the H4 applications. So that was the new thing in 2018 that didn't used to be the case. EADs and H4s used to be approved along with the H1Bs. That's not the case. We already discussed about the new lottery system that came in 2019. This is one of the good news compared to a lot of bad news that we heard in 2019 in immigration. This made it very simpler for employers, for the lawyers, for the employees, so that people can make their plans in their life. Previously, we used to file in the lottery, a lot of paperwork, and we don't even know we got it. And sometimes it even took until August to find out whether or not the person is selected in the lottery. That's a good thing that happened in the lottery. Also, as Emily pointed out, the University of Farmington has been exposed. Though it started in 2016, it got exposed in 2019. Please do expect same kind of things coming out, either fake universities or fake employers or fake employees that will take themselves out pretending that they're employees or employers or universities. Be careful. Our advice is to not make sure that you comply with the laws. And if you have any doubt, please check immigrationworld.com. She updates everything up. And we do have a Facebook and YouTube presentation every week on Tuesday at 5 p.m. Central Time. You can log in and ask us live questions there. In 2019, we have seen that there is a social media questions that have been added in the DS-160. So whenever you go out for, visa stamping, the new requirement, that the social media requirement, which didn't used to be there before, was now introduced in 2019. Any important things I missed in 2019, Emily?
I think that, if we look back at the 2019 lottery, there were over 200,000 applications filed. So you can only imagine, with the ease of this new registration process and the economy that's doing well, low unemployment, expect a high number of registrations filed in the lottery this year.
Okay. I'm going to go through what is expected in the 2020, guys. Of course, any questions on this you can ask later on. We're expecting that the EB1 worldwide demand will be there. It may go a little bit lower, but the demand will be there. EB1 will be backlogged in 2020. Also, social media questions are coming up in the 485. That means the adjustment of status application when you file the green card, and also when you file for the citizenship application. Even for those people who have a visa waiver program, that means people like, for example, UK nationals, or some of the European nationals where they don't have a visa requirement, they have to fill the social media requirement before they enter into the United States. So expect more scrutiny to be coming in. They're expecting that the premium processing time, which used to happen in 15 days, they may look into working days for 15 days rather than calendar days. So that might delay more in 2020 for the premium processing. The good part is that the premium processing, which was blocked out in 2018, they did open up in 2019. They increased the fees a little bit on the 2019, but it still is open. We are not expecting any more changes other than the calendar days instead of the 15 days. We are expecting that the filing fees for the 485, which also included that means adjustment of status, which also included for the EAD and advance parole, now they are proposing it is expected that for the employment base, filing fees is not included. So for those people who file the adjustment of status, they get stuck there. Some of them, they get stuck there from 2007 onwards for a period of 10 years. They have to renew. Sometimes every year, the advance parole and EAD, they will be paying a hefty sum of money to the USCIS. I am not sure if this is a good news or bad news, because previously when they used to have the I-131-765, they opened up and allowed all the people to file the adjustment of status, at least most of the people in 2007. I don't know if this may be a good news, because immigration likes the money. They may open up because they're going to collect more money every time you file the EAD in advance parole. We may see some advances, but that's just my hope. I don't know, Emily. What do you say? Just because they have the filing fees increased, they may allow more people to file the adjustment of status, Emily?
Oh, that's a great question. I probably disagree on that, just because they like to delay that 485 filing as much as they can. But we'll see how it goes.
I'll keep my hopes up, Emily. Let's see. Maybe they'll improve they want their money. So if they allow a lot of people to file the adjustment of status, that's what happened in 2007, guys. They made everybody current and allowed them to file, but they didn't give them the green card. So maybe they won't go that extreme, but I'm expecting maybe some movement, because they like the money that you guys pay. Also in 2020, we're expecting that the Department of Homeland Security is going to change the definition of the specialty occupation and employer-employee relationship without changing any definition, without changing any rules, without changing any regulations. We saw an increase of 10 times the denial of the H-1B. Imagine, guys, if this regulation is going to go through, it's going to be a nightmare. But this is what they are proposing. There is a proposal that there might be a biometrics for the H-1B people also, just like the way we have for the H-4 people. That's going to increase the timeline, and we don't know how that's going to act with regards to the premium processing, because fingerprinting will take more time. We're expecting that the H4 EAD removal timeline might be coming up. They are saying that in March of 2020, they may come up with a proposal to remove the H4 EAD completely. They've been postponing it. We don't know if they are going to postpone it or they're going to implement it in March of 2020. Let me check any more. Also, with regards to the regulatory changes are expected to come on wages to be paid to the L1Bs, and some L1B specialized knowledge definition is going to change. All these changes are expected to only increase the burden and also increase the denial rates. On the student visa, when people come in, they get into DOS, which is duration of status. They are no longer going to get it based on the proposed regulations, which are expected to come in 2020. They will be given a certain date. In other words, they will have to extend the I-94. That is going to be a big burdensome when people want to move from one university to another university. Any other important things I missed out, Emily?
ICE is planning to make some changes to optional practical training, which is the OPT. So we might see more restrictions on the 12-month and the 24-month STEM OPT. We also have OPT litigation that's been going on for years, where a group is trying to restrict the 24-month STEM extension from happening. So we might see a decision on that court case sometime in 2020.
Going back to the next topic with regards to what's going on in Abu Dhabi, students that were trying to come back from Abu Dhabi University, to our knowledge, at least our office has spoken with 15 to 16 people, either them or their spouses we have spoken with, that were being deported. These are the students that are coming back. And these are the common things that we noticed in them on a student visa, either on OPT or STEM extension. They worked outside the scope of the employment. They worked in either gas station, liquor store, restaurant, or grocery store, which was not allowed on the OPT. And that's the reason, that's one of the things that we have noticed. The second thing was that there was a picture on the internet or on the phone that they actually worked for this particular out of the scope employment. The third thing common that we noticed is that there was a cash deposit, either bi-weekly or monthly, that was there in their bank account. These are the common things that we noticed, why they have been turned back and come back to their home country. Now the fact is that how do they know? I mean, nowadays it's an electronic digital age. Everybody knows everything, especially the government knows everything. When you are entering into United States, the Custom and Border Protection people can demand to see your smartphone and also ask the passwords either for the Facebook, for also WhatsApp or your bank account, and have it open for them to see if there is anything that is culpable for you. You may not have much rights. Emily, if they refuse to give the password, what will happen? If they refuse
so you
to
do
open
have the
phone,
option. Yeah, you do have the option of refusing to turn over your cell phone or your laptop or your passwords if you are a non-immigrant entering the country. Unfortunately, that gives CBP the option of refusing to allow you entry. So if you think there's something on your phone or laptop that could be problematic, you may be in a better shape if you just withdraw your application for admission rather than turning over your devices and letting them find all of those things. Because if they do see all of those things, they could put the individual into what's called expedited removal, which is basically another word for fast deportation that happens right there at the airport. And if you are subject to expedited removal, it becomes a 5-year ban with very little options to come back to the U.S. during that 5-year period. So better to refuse to turn that over and just go return on your own.
What Emily is suggesting is not refuse to turn your phone or laptop. What you mean to say is refuse to give them the passwords. Emily, but in the people that got deported in Abu Dhabi, most of them were being given permission. They were been given permission to withdraw their application and go back. None of them have been expeditedly removed, at least in the past 2 weeks. So is it better to turn and give them the password and then withdraw the application, or refuse to give the password and withdraw the application?
Well, yeah, it's a good question. I would rather, if there's something on the phone or in, that could show that you've been violating U.S. immigration laws, I think it would be better to withdraw your application for admission rather than giving over your device, letting them make that determination, and then having to withdraw it, because you can guarantee that whatever they're finding, they're making a note of it, and it's going to be in your record that could come back to haunt you in the future.
Any other things I missed, Emily, before we go Q&A?
I think we're ready for Q&A.
Good.
Any questions?
I request all the members to post your questions in the chat window, because if I unmute, it might be like a lot of disturbance. So yeah, I got the first question, Rahul. 2020, let me expand this. 2020 H1 registration process is only for new, or the same rule applies for all? Is there any problem with switching employers?
The question is the 2020 only for new? It's for all. I don't know what you mean by new. This question comes from Prashant. I don't know what exactly do you mean by new. It's for all.
I think they mean the CAT cases.
Oh,
is it only subject to CAT cases, or is all extensions and transfers and amendments have to go through the registration?
Yes, you're right. You're right. Go ahead with the answer.
So no, this registration system is only for the new H-1Bs, meaning the CAT subject H-1Bs that are required to go through the lottery. Transfers, extensions, amendments are not impacted by this new rule.
Prashant has this question. Can two different employers apply for H-1B for two different projects, one current and one future project? Prashant, we have noticed with our own office, at least 8 of the employers have gone into jail that consulted us in 2019. Actually, the number is a little bit more. And there are a lot of employees that got affected, that filed like the way you are speaking about. The problem is when we announce these things in the Facebook and YouTube, we can't give the evidence for those things because those people are not willing to come to the Facebook and YouTube and sit down with us, either the employers. And of course, you know, Prashant, there is a confidentiality between the lawyers, so we can't, our advice is do not do that. Do not do that. Don't file for the duplicate. It's always almost fraud. Please don't do that if it's a duplicate. And do you know exactly what time they are going to conduct the lottery, and the people can find out when the lottery results are going to happen?
We don't know exactly when they're going to conduct it, but they did say for sure you will know by March 31st. So within a 10-day window from when the registration window closes on the 21st, by the 31st, you'll have an answer.
Okay, the question comes from Kay. He says that his I-129D is pending. Is it okay to employer to file his name in the lottery? I'm assuming the I-129B is for the appeal for the H-1B denial for the 2019 April filing. Absolutely no problem, sir. Your employer can file. Even though your H-1B is pending for the 2019, 2020, you can still file the lottery. Do you see anything wrong in that, Emily?
No, definitely no issues with that. The only thing I would just make you aware of is if you are selected in the lottery, at some point during the process of that case, if the appeal is still pending, they might ask you to choose one to move forward with. So especially if this would be where the same employer is filing in the lottery that also has the pending appeal. It's a different employer. I've not seen an issue with that at all.
The question that comes from Neil is that he is an L1A visa. Can he now move to the H1B based on the previous H1B and I-140 approval? Neil, the only question is that we need to know, Neil, is that you said your H1B is approved. I'm assuming that you were here in the United States on I-94. If that's the case, we don't see any problem whatsoever at all to moving from L1A to H1B based on the I-140 approval. Now, if you had the H1B stamped in the passport, that is good enough for you. To be counted in the H1B number, that you must have an I-94 of the H1B, or you must have at least have a passport stamping with the H1B. If none of them are there, you're not counted, but if any of them are there, you're counted toward the H1B number. A question that came from Nandini. One other point that we want to mention too is that if any of the people have ever worked on the student visa, other than the prescribed DSO, where the DSO has authorized you to work, if you have worked for any place for cash or anything like that, you need to contact the lawyer immediately. A lot of people assume that the government doesn't know. I don't know if you guys have any clue. Right now, the government tracks all the people on different ways. They have face recognition videos, they have different things to track it. So if you have ever done work, I would strongly recommend that you contact a lawyer. Kishore, if you can read any of the questions that you can, that's fine.
Yeah, sure, Rahul.
Is there any way you can only have certain people on the conference call that want to ask questions, like a *6 or something like that?
No, but everybody is posting their questions, so we'll see until 7. I have a question on traveling during H1B selection process. If my registration got selected and I am coming back from other country, will I have any problem at port of entry?
It's technically a wrong thing to come on a student, any other visa, once your H1B is selected in the lottery system. Even though we haven't noticed any problems in the previous years, where people are selected in the lottery and they entered into the United States, we highly, strongly recommend that they should not be doing that. They should not be traveling while this whole process is going on. Emily, you have another, what do you say on that?
Yeah, I agree, especially those that are coming in on F1. You know, every time you enter on F1, it's a non-immigrant intent type of visa, meaning you have to demonstrate to the officer at the port of entry that when your F1 time is up, you intend to return to your home country. But that can be difficult to do when they see that there's an H1B on your behalf in the system. So you could, although technically there's nothing saying that you cannot travel during that period, it is very possible that you might be denied admission by an individual officer at the port of entry. So it's a pretty big risk to take. Nandini
is asking the question. His friend has been deported from Abu Dhabi airport. Does he need to hire a lawyer before he goes for the visa stamping? The answer is yes. They need to hire a lawyer before they go for a stamping. A lot of people are doing a mistake. They already did one mistake, which they are not aware of maybe, but now it's aware of. Don't do the mistake of doing by yourself once you're already deported. There are a lot of things. People, if you are deported from the Abu Dhabi, we are advising them not to go to a student visa at all, to apply for the student visa. And they have to fill the forms and the DS-160. before they fill and complete the form. They strongly recommend, we strongly recommend that you contact a lawyer before you do anything. 1 second.
Next question is, when is the exact lottery will happen? You have mentioned that we have time until June.
It will happen. No, the lottery will be concluded before March 31st. However, you have time to file the H-1B application from April 1st to June 30th. So, for example, if you're selected in the lottery and you'll get a result by March 31st, you have 3 months to file an application. Last year, previous years, and all the previous years, even from 2007 to right now, we had only 5 days, up to 5 days to file an application. Actually, in 2007, it was only 1 day. And later on, they implemented that, okay, we'll allow it 5 days. Right now, we have 3 months to file the H-1B application. And if the application is not received within 3 months, then we're going to, you can't file it. But 3 months is a lot of time. People can complete that.
Okay, so Rahul, that $10 is only for that March 1st to March 31st, just to file that electronically. But
that is right. The filing fees will be only after you're selected in the lottery. Then you will go and file the entire application at that point of time, depending on if the employer has more than 25 employees or less than 25 employees, depending on if the employer has more than 50 employees, out of which more than 50% of their employees are on their H-1B or L-1, the filing fees will differ.
Okay, so there is no change in the H-1B filing fee as of now.
No, don't give any crazy ideas to immigration for now. They increase filing fees by a little bit for the premium processing. They are also expected to increase the filing fees, but hopefully not by the time we get this into the lottery.
Next question, Emily. For H-1B amendments / notifications with extension, can this be filed while the beneficiary is out of country?
Can an amendment be filed while the beneficiary is outside the country?
Yeah.
Yes, it can. So you have the option of selecting on the H-1B petition either amendment plus extension if you're in the U.S. or amendment notify the consulate if you're outside the U.S. at the time of filing. And once it's approved, then most likely you would take that approval, get the visa stamped, and come back in. Or if you already have the visa stamp and have the valid I-94 from your previous approval, then you should be able to come back in with your valid visa stamp and your amended approval and the previous approval.
Nandini has this follow-up question for his friend who got deported, and if he goes to the interview, he applies for the visa after he's been sent back from the Abu Dhabi airport. What are his probabilities? We can't tell, Nandini, based on what visa he's applying or what he filled the DS-160, but I can tell you one thing. Any wrong information on the DS-160, he will be permanently barred to come into the United States. That's for sure, I can tell that. Any wrong thing, he does it. I would strongly recommend that he withdraw the application rather than actually go without legal representation. A good question that came out from Vetri Emily. He's an L1A and his I-140 is approved, Emily. If he changes to the H and his EB1C has been approved, and as you know, Emily, that he cannot file the adjustment of status. If he moves to the H1B, can he use the EB1C once the priority date is current, or does he have to go to EB2 or EB3?
That's a really good question. So as long as, the L1A job, the EB1C job, and the H1B job can all be the exact same job. You're just using different categories in order to get the visa. So assuming that the H-1B job that you're being sponsored for is the same as that EB-1C job, you can absolutely continue with the EB1 green card process when the priority date becomes current. Now, if instead you're saying you're going to change employers to get the H-1B, that's a different story. You're going to have to go through the labor certification and I-140 process.
What if he doesn't change the employer? Can he downgrade his job because now he cannot be an L1A and then upgrade once he gets the green card? Because green card is a future employment anyway, Emily.
As long as he intends to join that future job and the company is going to keep that open for him, I don't see any restriction on that, because you can be in a different job today on your H1 and be sponsored for a future job when you get your green card, as long as it's a valid job, bona fide job, employer's keeping it open for you, and you intend to take that job.
Emily, is there a URL link for the employers to register right now, or is it going to come?
It's not available yet. We don't know when it will come. USCIS did say it will come before March 1st so that you can get your account set up and be ready to go, but they did not give us a date or an actual website yet.
I advise Nandini, you have been posting too much questions on the person. Nandini, just have your guy contact a lawyer. Please don't post any more questions. It's required for him to contact a lawyer once he's been deported. You don't want that guy to represent himself. It's very dangerous, and I don't know how to say to you that. Any more questions you can pick up?
This is on EB1 backlog. Are you saying that there will be no movement at all in 2020?
No, there will be movement, but there will be a backlog in 2020. There will be movement, but remember, Kishore, there was no backlog until 2019. There was no backlog in 2018. The priority date used to be current. We are not expecting in 2020 the priority date to be current for EB1. But it will move, but it will not be current according to our expectation.
Okay.
Trying to read the questions.
Next one.
This question comes from Sai. His H1B is approved in April of 2019, but his wife's H4 and EAD has not been approved. Even though his biometrics are done, what is the solution for this one? Sai, you've been missing our Facebook and YouTubes. They are not adjudicating the H4 and EADs starting from March or April of 2019. I can't remember the exact date. In March, I think so, from starting. The best way to approach is that you go through the federal court litigation. Reddy and Neumann PC has every other week, we take approximately 50 people to take to the court to get it adjudicated faster. That's the only way to get it right now. Yes, even though your H1B is approved in April of 2019, they are not adjudicating the H4 sooner. They are not adjudicating along with the H1B. Is the H1B registration and lottery are different process? No, it's not a different process. It's the same process. Maybe the wording that you and Emily we are all using is different. The way is that the employer register themselves, then they add the employees in it. So it may not be in the same one step. It may be two-step process. Registration and adding the employees might be two-step process. It may not be one-step process, but it's still in the same login that you have, that the employer will be able to add the employees. This is what we are expecting it. That's what they're telling us, but the URL is not there. Once the URL is there, Desi Friends is going to let you know on that. Any more questions, Kishore?
Yeah. So if H1B is approved for X years, H4EAD is applied and approved, During this approval process, what happens when employment changes?
If the H4 and EAD is approved along with the H1B of company A, okay, and if the person moves to a different job, let's say he moves to company B, the H4 plus EAD is still active. They can still continue working until the H4 EAD expires. However, Kishore, though, there are situations where, in the same scenario what you said, let's say, for example, the person is working with company A, he filed with company A, and the H4 and EAD is still pending, and then he moves to company B. We are strongly recommending them to file with the company B also the H4 plus EAD as a safety precaution, because sometimes since the previous company A might withdraw the H1B, they may accidentally deny the H4 plus EAD. That's the reason if they move to company B and the H4 and EAD is still not approved, we're strongly recommending to people to file for H4 plus EAD. Any more questions? Normally it's Emily and me, we both read the questions so we can catch up. But since I'm reading, Emily is driving, not used to it. What is the time period? The question that comes from a phone number, actually didn't put the phone name. What is the time period that is required to file for the EAD advance parole? The time period for the advance parole, I think so he's speaking about the filing fees. When will it occur? When we are going to issue the regulations on the proposed regulations on the EAD and advance parole, do you think so that they're going to go with the existing applications or only future applications? When I say existing applications, only what I mean to say is that the people who are already filed adjustment of status, would they tell them to pay the fees for every extension or only for the further filing people?
That's a good question that I don't think was 100% clear in the proposal. Now, based on what they did in the past, when they took away those filing fees, they did it based on when you filed your 485. So hopefully that means we'll have the same rule this time around. So people who have already filed their 485 under the old rule where the EAD and AP was included, they should not have to pay for fees to renew. But going forward, new people that are filing their 485s will have to pay. That's a guess just based on how they did it last time around, but I don't think it was clear in the proposal.
I may disagree with Emily on that. Whenever there is a money issue that they need to get it, they can drag as much as money as possible. I think so they're going to go with the existing applications too. This is a question that comes from Prashant again. The same question, 2 different companies, 2 different tax ID numbers, filing 2 different lottery systems. Why is it a problem? One company is a Google, one company is a Microsoft. Prashant, I don't think so Google and Microsoft is going to file for you. If they do, let it be. Now, we consider that every duplicate application, the second, if you're not working for the company, we consider it as fraud. When 9 employers who took our advice, after they got into trouble, they came and took our advice, went to jail. When approximately more than 100 people in 2019, H1Bs were being revoked, we cannot tell that it's a genuine application, Prashant. I don't know what, we can't. It's up to you guys. And then we tell people not to get into these things. They get into trouble. Look what happened in Farmington. They got into trouble. Look what happened in the University of Northern New Jersey. They got into trouble. Look what is happening with Abu Dhabi. If you're thinking that your companies have 2 tax ID numbers, they don't know each other. We know these fraud, guys. I live in the same community, Prashant, what you live in. I know all these things what happen. So if you want to file duplicate, I would strongly consult with an immigration lawyer, have him certify that it doesn't look like fraud, you can file. Then it may be up to you to file it. And I have not I think so I may have certified only one guy in 2019. And that guy happens to be from Stanford, not Stanford, Stanford University. And he got 2 jobs in a top IT companies, only one guy. And about 40, 50 of them consulted to me to file for duplicate. I said no to everybody. What, any different opinion for you, Emily? 2 different ideas.
I agree with you 100%. It is very rare for one person to receive multiple job offers from multiple legitimate companies. Like you have only had one person, I've only had one person in the past 5 years that I can say, I could comfortably say, yes, you can go ahead and file these 2 petitions. One person out of 5 years.
Sandeep has this interesting question, Emily. His extension is pending and his 240 days is expiring. He knows that he cannot work after the I-94 expires its 240 days. Can he stay in United States until the H-1B decision comes out?
Yes, but please upgrade to premium processing and get it over with. I just don't understand how these ever can get to 240 days.
There is a rumor out there, Emily, in the immigrant community people saying that the premium processing will get you RFE, it'll get you denial. How truthful is that?
It's just not true. I think that's completely false. I file a lot of petitions in premium processing. I recommend to all of my employers, file in premium processing when you can. You get a better level of customer service. You get peace of mind knowing that it's taken care of before your I-94 expires. There are no increased RFEs, no increased denials simply because you paid them extra money. If the case was going to get an RFE, it would have happened whether you filed it in premium or regular. If it was going to be denied, it's going to happen whether you upgrade to premium or keep it in regular. I think people just get upset because they pay more money to end up with an RFE or to end up with a denial, but it wasn't the premium that caused the RFE or the denial.
Kishore, anything you have?
Yeah, if I-140 is approved, I am hearing that EAD is getting processed by a bill proposed that was pending. Is that true?
There are too many bills that are proposed and pending. Nothing has to be taken seriously about those bills, though. The major thing that I would say at this point of time where people need to be aware of Senate 386 bill. That has a little bit higher chance of passing, which all the people should support it because this eliminates the discrimination that is being caused right now. If you are going to go with the proposed bills, there are approximately around 68 or 70 bills, but none of them has any seriousness in passing. And even if some of them are more, most of them might not be related to the business immigration, but we don't see any serious bill that will say that if the I-140 is approved, the EAD will be processed. We don't see any serious bill coming out. They could do it in the regulations if they want to. The administration can do it if they want to. The Obama administration came very close in processing the EADs when the I-140 is approved, but they backed off. Had they done that, that would have been heaven for everybody. But they backed off, and that's a very bad thing that happened. Any other things we missed out, important things, Emily?
I think I don't remember if we discussed, but just to be aware, one of the proposed regulations to expect this year is to eliminate the option of filing the I-140 and 485 together, which I know for a lot of people, country of birth India isn't that relevant.
Yeah.
But if S386 were to pass, I think it would become more relevant.
The question, if S386 bill is passed, though, still we are expecting priority date to be backlogged all the way to 2000. According to my calculation, it's coming. It won't be crossing the 2016, according to my expectation, at least in the first year, maybe later year. But then most of the people will file in premium processing too, the I-140, so they should be fine. Another question came in on the EAD and advance parole. How early can you file an EAD and advance parole? EAD and advance parole can be filed within the span of 180 days before your EAD expires and advance parole expires. Now, the good part about the EAD for the adjustment of status people only. Now, this is not for the H4 EAD, another only adjustment of status EAD only is that if you file a timely extension of the EAD under the adjustment of status, even if the EAD is not approved, you can work for up to 180 days after your EAD expires. So that's a good part for the adjustment of status EADs. That's not applicable to the H4 EADs. Anything else,
Take
Kishore?
one last question, Rahul. My I-140 is approved from my current employer, and it's been just 4 months now. I want to switch after 180 days of I-140 approval. How can I get my I-140 number? And when should I apply for it from USCIS? As my employer is not...
How long it's been that the I-140 has been approved, he said?
It's like 4 months. And it seems his employer is not willing to share the I-140.
There is something called Freedom of Information. If the person is listening to FOIA, Freedom of Information Act, and type it in Google, FOIA, USCIS. There'll be a form that you can fill it out. You can fill it out, and once you fill it out, it takes approximately 1 to 2 months for you to get it. You can fill it out online. It is so easy application. You don't need a lawyer, unlike the other person that I was suggesting, where the person got deported. Don't go by yourself here. I'm suggesting you to do it by yourself. Go it FOIA, USCIS, fill that thing out. It'll take 30 days to 60 days to get an I-140. They won't give you an I-140 approval, but they give you the I-140 petition, but that will give very clear guidelines, when it is approved, what is it, and that's all you would need it. It's free, it's easy, it's online, and no filing fees, guys. Thank you, Kishore. Anything else?
No, Rahul, I see it is already past 7. So there are another 50 questions, but just to remind all the members that we have daily calls from Rahul and Emily, and we post that information in all our groups. So you can use those sessions to ask your questions. And Rahul, as mentioned, they also got the Facebook Live. Is it on Tuesdays, 5 p.m., Rahul? Or?
Every Tuesday, 5 p.m. Facebook and YouTube Live.
Yeah. So you can also use those sessions to get clarifications for all your questions. So once again, thanks Emily and Rahul. Thanks a lot for taking time, and have a great weekend.
Thank you.
Thanks for having us.
Thank you, Emily. Thank you.
Thank you. Thanks everyone. Bye.